and 314 for a shooting at Century Theaters. They're saying somebody's shooting in the auditorium.
Roger, keep your fires west of the smoke. You're cleared hot. An officer hit. Send me the world.
Don't go over that fence. Don't go over that fence. Grab the shotgun again.
Welcome to Tactical Tangents.
Welcome back to Tactical Tangents. This is Mike. This episode is brought to you by Mantis. Mantis is a firearms training tool that helps you in both live fire and dry fire. If you want to improve your shooting skills, you can use the Mantis for shot-by-shot performance. Go check them out at mantisx.com.
This episode is also brought to you by Drip Drop. Drip Drop Oral Rehydration Solution was carefully formulated for fast absorption of water and salt without excess sugar. It doesn't totally replace intravenous fluids if you need that, but it is a lot easier than getting the shot. You can find it online through a number of vendors, including dripdrop.com and Amazon. But also, I would offer that if you're a government employee and you're being forced or directed to train out in hot, dry environments, consider asking your supply guy to supply you with it, right? Go to your supply guy and point out that it has a national stock number, and they can find it on GSA Advantage.
Tonight we have a really cool guest with us, the Honorable Judge Edward Lee, also known as Ned Lee. He has an incredible background, and we're excited for this interview. And Jim and I have been fortunate to have known and interacted with Judge Lee for a long time and a bunch over the years. He was an Army infantry officer in the National Guard. You might still be. Are you still an Army infantry guy?
Yes, I'm now in the California State Guard, which they don't even pay me at all for, but I just can't figure out how to quit.
Is that like the California militia?
It's just like the California militia. I'm sure the FBI is going to monitor this very carefully, but I'm what passes for a brigade commander in the California State Guard, but that's after 20 some odd years as an infantry and military police officer in the regular guard.
That's awesome. And he also did some time as a police officer and a prosecutor, and you've spent the last 20-something years, 20 how many?
28.
28 years as a judge for the Superior Court in California, and mostly in Northern California, but we don't need to get into the specifics. Thanks for being here, sir.
Yeah, as my wife points out, I just can't hold a job, so it does provide an interesting and varied background.
So, just kind of a neat thing about Ned in the context of this podcast is we talk about military stuff, we talk about law enforcement stuff, we talk about civilian, self-defense and carry stuff. And Ned is a triple threat. He has done all of those things and achieved mastery in all of those things at a professional level, which makes him a really unique and an awesome resource. And he has mentored us through the Civil Air Patrol program also for many, many years. And one of the things that has always stood out to me about him is his social awareness and charisma have allowed him to work in these very contentious, sometimes very dangerous environments and help people get to a solution on that. In fact, he was the one who introduced me to the phrase verbal judo, or as we like to say here, gerbil voodoo. Ned, can you talk to us about just your speaking skills and how you developed them?
Well, I think it mostly started out with something that Mike might be aware of, is I was a 150-pound police officer, and to avoid getting my ass kicked on a more than regular basis, you have to develop the skills necessary to get the job done without physical confrontations. And sometimes that means you have to be able to speak more quickly and with greater wisdom than you might otherwise do so.
I like it.
So I'm always going to say Judge Lee because I think your service and your time on the bench is just a something that a perspective that people probably just don't get to hear a lot about. And it's, we talked about being an infantry officer and a police officer and working for the district attorney's office. And then now all the years that you've spent as a Superior Court judge. So it's always Judge Lee to me. I think that's so cool. And there's so many things that we can talk about. But one of the starting points for me is Are there 2 or 3 things that you wish police officers knew after watching them shit the bed for the last 28 years? Because I feel like cops get really intimidated by attorneys and going to court, and they take what is really not that difficult of a thing and they complicate it for themselves. So do you have a couple takeaways that you wish cops knew?
Sure. It's the attorney's game, right? I'm there to call balls and strikes and make sure nobody gets abused. But oftentimes cops, and I think experienced cops more than rookies, will come in and they'll try to be cleverer than the attorneys. And it's their game, and they've been doing this for a long time. And what may sound clever or good in conversations at 3 a.m. at a shift party over the hood of a car and pizza don't work well in front of a jury. And so don't try to outsmart the cops. For the rookies, it's sort of the other way, is turn off the jargon. I had a nickel for every time a cop with less than 2 years experience dismounted his police vehicle or rendered a firearm safe instead of getting out of his car and unloading a gun. I would be a rich man indeed. It's just, you just have to be as natural and understand what's going on and let the DA lead you. For God's sakes, if the DA says to you while you're testifying, would it help to refresh your recollection if you were to take a look at the police report? The answer to that question is yes.
Hint, hint.
And yet I've heard cops say, no, I remember it pretty well. Are you sure, officer? Yeah, I'm sure. I would just go, well, this will be fun to watch.
And this touches on topics we've brought up in the past, right? There's a certain personality that makes a cop. And, most cops are wired to be in control of their situation, and it puts them very kind of off balance when they're in a situation where there's obviously somebody else kind of taking control of the narrative and stuff. We've also did an article about writing for cops and how report writing can be problematic, right? You write things in a way that the lawyers don't understand or the jury can't understand. Ned, have you ever seen examples of that where writing got a cop in trouble?
Well, part of the problem is attorneys don't understand why police officers write reports, right? We have to write reports. Cops have to write reports, even if the case is never going to court, right? You could arrest somebody for a warrant and there's still going to be paper for that. Because you're documenting how you spend your time, you're trying to keep things on the paperwork is all good, and accountability for property, even if there's no criminal stuff involved. And attorneys don't understand that, and they don't understand that police reports are there to help you refresh your recollection for testifying in court. But of course, you didn't write everything in the police report, or the police report would be 300 pages long. They're there to cue your memories and to assist you in your recollection. And if I had, again, I'm collecting a lot of money tonight, but if I had a nickel for every time some attorney said, officer, were you trained in how to write reports in the academy? Oh, yes, I was. And weren't you trained to include all the important facts in that report? Yes. And so if my attorney or if my client had done X, Y, or Z, you would have written that in the report, right? And the cop has to say, not necessarily, and then explain it. And it's just a fundamental mismatch between expectations.
Yeah. That exact thing has happened to me a number of times, and I basically say exactly what you said, is that this is a tool to help me remember so that I can explain it to you today, 1. And 2, it's very difficult to put what was a 360-degree situation that I had all 5 or even 6 of my senses available, and to try to put that in a linear written form. There's no way that I'm going to be able to capture all of that on paper. So if there's something that I missed, it's not on purpose, or maybe it was, but that happens.
Or it's your beat and you're writing paper and 3 other cops were there before you were, but it's your beat, so you're writing the paper, so you have supplementals, and the attorneys can't keep track of who wrote what. And they're convinced there has to be one arresting officer or one case officer. And you go, well, we all kind of did it.
It's a team.
It's a team. I did the arrest report. That's my name down there, but we're all arresting officers. So there is a fundamental mismatch, I think, sometimes between how attorneys are trained and what the cops would think of as the real world.
Which brings up another interesting thing that cops have to be careful about, which is the whole hearsay issue. And so for anyone listening to this who maybe is trying to become a cop and doesn't know this yet, or if you are a person that is not familiar with the legal system in criminal trials, I cannot speak to what someone else told me because that person has to come into court and say it themselves. So if Officer Joe told me one thing, you have to be kind of careful about saying Officer Joe told me X, Y, and Z, because Officer Joe should be there to explain that. And I think Ned, earlier you said that it's the attorney's show, and this is one of the things that one of my mentors explained to me was that your job as the witness in that case is to go up there and to sell this story in a truthful but also entertaining way. And the prosecutor is sort of the director of that. So it's not really, it's the prosecutor's show in a sense. They're supposed to sit there and direct you to share that picture and the other witnesses, right? Is that, do you have any thoughts on that?
Well, as a former prosecutor, I can only agree. I tell the cops to think of themselves as non-player characters, right? They're there to do a certain thing and recite what happened, and I'm pretty sure I know what you're going to say because that's what you wrote in the police report. And by the way, if that's not what you're going to say, we should have a conference about that before you get on the stand. And I wouldn't, as cops, I don't want them to get too worried about what's hearsay or what's not. If some attorney says, what happened next? And you can say, well, Officer Jones told me that the defendant ran away. And if they ask the wrong question, that's fine. You gave a truthful answer, and there'll be a hearsay objection, and I'll deal with it. But don't do the attorney's work for them. Answer the questions as carefully and truthfully as you can. And when the defense is asking questions, your answer should be as short as possible. If yes will work, say yes. If no will work, say no. And if it won't work, say, it's hard for me to explain. Can I explain? Or that will take a few minutes or something like that.
That reminds me of a couple other things. One is, and maybe this is a product of that, like cops shitting the bed thing. And I say that
lovingly.
In a loving way.
In a loving way, yeah. Like, one of the things that I want any cop listening to this episode to take away is how to do better in court, right? But I've gotten to testify a bunch in court, and on cases that I was the case officer or primary officer for, I've gotten to watch other officers testify, and I've seen them struggle with some of these things. And so I think, again, like you said, Judge, you don't have to worry about the hearsay thing. That should be their thing. But I think having a basic understanding of that, and one of the things that I have seen, and I'd love to hear your take on this as a prosecutor and a judge, is I think some prosecutors are a little wary of giving the officer too much rope. And so I've had that come up where a prosecutor will ask me a question and there's more to it, but they haven't given me the opening to explain it better. Right. How should an officer handle that?
Well, you could say there's more I can explain. And if the DA says that's not necessary and what color was the sky, you just go with what they've got to say. You can make the offer to the DA and he or she can take you up on that or not. To me, when I was a prosecutor, especially working in a specialized unit, I did some large vendor narcotics prosecution for a year or so. And we had certain case agents, certain guys who were, on the task force and whatnot.
I like the term large vendor, like Costco of dope.
Multi kilos kind of stuff. Back when we could actually have multi kilos of dope in court, they make a very resounding thud when you put them on the table. The good old days. But there were certain officers that I could just wind up and let them go, and it was the pause, pivot, spiel method. So I would ask a question, they would look at me thoughtfully, they would pivot towards the jury, and they're off to the races, explaining their expertise. And there's an important time for them. Because these are the actual expert officers who've been working dope for God knows how many years. But it's not a good time to let the guy who's been on for 3 years, who's testifying about metallurgy or something in a DUI accident. So the prosecutor has to be familiar with her case, and you have to work with the prosecutor. But all things being equal, just answer the questions, and you'll be just fine and relax. Don't let your baton get hung up in the witness chair. Give it to the deputy. I don't know. These days, the external vests are very popular. I just think they're a little off-putting to the jury. I like guys in their regular uniform or their Levi action suits or whatever it is. But if they look a little too much like a ninja, then I think sometimes it can affect their credibility.
That was actually used, if you recall from the Ruby Ridge case, you, the listener, have recalled from the Ruby Ridge case, the defense attorney in that case had the marshals stand up in their ghillie suits, specifically to show how intimidating they were and how foreign and scary they were to the residents. The kind and gentle citizens of Ruby Ridge, Idaho. So the theme that I'm getting from this is that, as neither the cop nor the judge, is that police officers have to trust the prosecutor through the process, right? You're in the prosecutor's world, and he or she knows what they're trying to accomplish in that case in order to achieve a result. And that can be frustrating, I imagine, as the cop, where you're like, I'm not sure this prosecutor knows where they're going, or something like that, right?
No, and I can tell you that happens, and there have been times where the prosecutors have missed, I think, important details that if they had asked me about, probably would have helped. And Judge, you could tell me this if you have noticed this tactic, or if you've ever employed this tactic. I've noticed in some cases, the defense attorney will lay up off of me and then focus more on the prosecutor. Like they're counting on the prosecutor to not introduce something because they know if they let me talk about it, it's gonna back them into a corner. Have you ever seen anything like that happen?
Sure, we talk about opening the door for evidence that would otherwise be inadmissible, and attorneys will kind of set traps for each other and wait to see if somebody talks about it, and that's just part of the game. The attorneys, I wanted to point out that there are rookie cops and there are rookie attorneys. And God knows I was a rookie attorney for the first 2 or 3 years in the DA's office. Now, I had an advantage in that I was bilingual cop DA, and not very many of my colleagues were. But that didn't make me any smarter than the other DAs. I just understood a few terms that the cops use that the DAs don't understand. So some case is going to be the rookie DA's first case. Hopefully it'll be theft of library books or a run-of-the-mill DUI or something like that.
Yeah.
But they get reassigned. And at some point they have their first murder case, or at some point they have their first domestic violence case, all of which require a different skill set and prosecutorial milieu, if you will. So there are times when the cop will know. But I'm usually making tactical choices as a prosecutor. I may not call you. I may call your partner, because there's some issue in your past, or your report had a typo in it or something like that. And I'm just trying to avoid that. And if I can get the same testimony from your partner who was standing there while the defendant confessed to you or the witness made a statement, then I will make those choices that I need to make. I should be able to explain that to you. It's not a hide the ball kind of thing.
Right.
But sometimes there are strategic things going on that the cops may not know about.
And I think that what's helped me the most is to just find the opportunity to talk to the prosecutor for a few minutes. And if there's not an actual meeting that you get to sit down with them, I've had, for example, cases involving my canine, my working dog, and in a narcotics detection role with the working dog, there's going to be things that they just do not necessarily have the expertise on. And so if you sit down with them for a minute and just explain what it is that you have to share, you'll probably, one, help give them the understanding that they need to open that door for you, and two, put them a little bit at ease with whatever it is that you have to say, right? Or
bring over a 6-pack and watch an episode of America's Top Dog and say, this is how dogs alert. It's unusual behavior. That kind of stuff.
Do you ever take the dog into the courtroom?
No, but my dog got stabbed last year, and that guy's sentencing hearing is on, it's coming up this month, and he's coming in the courtroom for that one.
Bless his heart.
Ooh.
Yeah, that's going to be fun.
Yeah. So you've spoken about your transition a little bit between law enforcement, prosecutor, and judge. Can you just talk us through your path? How'd you end up where you are? How did you go from one to the other?
Sure. I started as the usual 20-year-old idiot trying to decide what I was going to do in my life, because Civil Air Patrol had not prepared me for an actual career. And I was having trouble in school and that kind of stuff. And I said, well, I'll go be a cop. How hard can that be? Because I know a lot of idiots that are cops. I would be good at that. And so I went, and the first oral board, they asked trick questions. like, what have you done to prepare yourself to become a police officer? I go, damn it, I showed up. And apparently that's not the right answer.
That's not enough.
So, so I went back and got a AA degree in administration of justice. And while I was doing that, I started working as a crazy reserve officer for a city called Costa Mesa, which is about 110 sworn, have a helicopter, Orange County kind of place. And I was the reserve that lived 2 blocks from the station. So if they needed somebody to transport or do anything, I was always there. So I was a 100-hour-a-month reserve. And they had pay jobs, so I could actually make some money doing that. And so I finished school, I got a BA from UC Irvine, and then actually went to work for the UC Irvine Police Department, which is, I still wonder why I quit that job. They really have it. It's an interesting role, university police, and I didn't respect it enough when I had it. But they had girls, so that was okay. And speaking of girls, I started dating some girl in Northern California, and I had been promoted in the University Police Department. I was the detective in my 31 sworn agency. And so I decided the best way to successfully pursue the relationship was to go to law school, because they were testing for sergeant, and I knew that you can't lateral out as a sergeant from a University Police Department. So I said, well, thank you for the honor, but I'm going to law school. Yeah, that's what I'm doing. So I went to law school, worked as a reserve while I was in law school for another small police department. And then when I graduated, because I didn't think I'd pass the bar, who does really? I went back to work for a city called Redwood City, which is, again, about a 90 sworn agency on the just south of San Francisco. And worked graveyards for a couple of years until I was able to pick up a job in the DA's office. Did that while I was a DA. I was a crazy reserve for a city called San Jose, which is a little over 1,000 sworn. So I got the experience of being working in a large police department. And I had a special role because I was bilingual cop DA. And so I could both write the search warrants and kick the door. It was a lot of fun. And I was doing a lot of teaching, both of cops and prosecutors. And at some point, the governor said, hey, would you like to be a judge? And I said, sure, I'll do that. And after 4 years as a lower court or municipal court judge, I ran an election for the Superior Court, which is the general trial level court in California, and won that. And 26 years later, whatever it is, I retired. I've been retired for exactly 11 days. Still haven't got my first paycheck yet.
Muzzle tough.
And you wonder how this interview came to be.
So there are a bunch of follow-on questions to that, right? So you saw a variety of small and large law enforcement agencies, which most people never get to do. They either grow up in Podunk, wherever, and they're in that one agency, or they grow up in, New York City and they know that agency. And it's pretty rare, I think, to see many people do that shift. What was the biggest surprise for you going from small agency to large agency?
Well, you don't know everybody, right? When I worked for small and medium-sized agencies, when you call for assistance or need cover, you might get 3 units. You do that in San Jose, there'll be 10 or 15 cop cars behind you in less than 2 minutes. And it's an astonishing team to work with. And when you need a helicopter, there's a helicopter. When you need canines or horses, there's canines or horses, or guys on dirt bikes, or whatever you need. I worked as the vice prosecutor and was embedded in the vice unit for a period of time. It was just amazing to be able to work with those kind of specialized units. When I was a university cop, I was the detective, right? I was the court liaison guy. I went to the LA Orange County Burglary Association meetings. I did everything that there needed to be done on every felony and all the misdemeanors that I could handle. It was a significant change. And I do agree that it opened my eyes a little bit as to what it's like to work for smaller or medium-sized agencies. I mean, I distinctly remember having to explain to people at 3 a.m. that I'm a real police officer. I know it says University Police, but it's right there, 830.2. You know what? If you don't think I'm a real cop, you should take this to court. You should tell the judge that I'm just a university cop and I'll get 4 hours minimum overtime and everyone will be happy.
I may not be a real cop, but these are real handcuffs. So off we go.
That's right.
Yeah. And also, even if you lose, or even if I lose, I win.
That's right. So over the course of your career, I imagine you've seen many, many, many instances of violent physical criminal victimization. Are there any lessons that you've learned, from a tactical standpoint of how people get victimized that maybe people don't think of, or risks that you face every day that people aren't cognizant of?
Well, of course, there's the sudden out of nowhere meteor hits you victimizations that occur. But I think the ones that carry the best lessons are the ones that come from acquaintances, date rapes, people who place themselves. They have a right to drink and they have a right to do dangerous things, but sometimes, that dark alley outside the biker bar is not where you want to be when you have a lot of cash that you just showed inside. And I want to support the victims' rights to exercise their rights and to go anywhere and do anything and dress any way they want to. But sadly, more often than they at least think, it can result in a sudden and horrible victimization that all of us have had the experience of going to and being a first responder and doing direct intervention work in the community. One of the reasons that it's more interesting to be a judge at times is because you're a tertiary intervener, right?
Yeah.
The cops have been there and they've done what they need to do, and the prosecutor and the supporting agencies, victim witness, and all those guys have done what they need to do to try to support the victim. And then it's me, right? And I'm supposed to do justice in a situation where there can never be justice because you can never make the victims whole after some particularly horrible sorts of things. And that's when it gets tough for judges.
So with that in mind, is there advice that you would give, a young man or a young woman going off to college or going off into the world about how to keep themselves safe in a, potentially dangerous world?
Well, it's the fundamental paradox of getting a realistic risk assessment into someone who's 20 to 25 years of age, because by definition, they can't do a risk assessment that they would when they're 35 or 40 or, God forbid, my geezer age. It's a tough thing. No one wants to believe when you're 20 or 21 that you can really get your ass kicked. No one wants to believe when you're 20 or 21 that somebody might actually have a knife or worse in that situation that you're in. And all of the, I don't know if it's movies or TV that teaches us how to behave, it's tough. That's that paradox. It's trying to teach them to fear things that they don't fear and to be realistic about what's going to happen to them if they take certain actions like drinking. I mean, every one of us has gone to a bar and gone drinking, and every one of us has had probably more than they should. Either it's a team meeting. God knows, after National Guard drills, we would go off and conduct an after-action review of the weekend's activities at a place that serves things in buckets.
Wait a second. There's drinking in the infantry?
There's occasionally alcohol in the military. Now I'm shocked. I know Jim is shocked.
Roger.
All of us are shocked.
What?
Yeah, but and people should have a right to have a good time and to drink, and they should have a right to walk wherever they want to walk. But sometimes those combinations come together in a way that result in tragedy.
And a right to do it doesn't make it a good idea.
Yeah.
And speaking of those things, do you have any cool stories of defendants who have represented themselves? Because
it's your right.
That never sounds like a good idea either.
Well, I have a lot, of course, because I was what we call a self-represented litigant specialist. In other words, the presiding judge thought I worked particularly well with those folks. So I had everything from three strikers who got fingerprint burglaries, and they know they're going to prison for life. They might as well have some fun before they go, kind of people who introduced some errors, all the way down to, I think my last self-represented litigant trial involved two guys who were accused of setting up a cockfight. And they had certainly studied the internet and the sovereign citizen websites and the other sorts of things for all the material they would need.
Bless their hearts.
And of course, my job is to beg and plead with them to get an attorney. Now, I will support your right to represent yourself, but this is a bad idea.
Yep.
I'm telling you,
there we
it's
go,
a bad
right?
idea.
Yeah, it's your
See,
right.
the court reporter wrote that down. It's a bad idea.
Make sure we get that on the record.
Yeah. And you have to fill out a form. And if it says on a form, it's a bad idea. And they have to initial that part. And, I have to make sure they have at least a high school education or a GED, and they have some sense of what's going on. But you have a right to, if you have an attorney, you have a right not to speak to your attorney. You have a right to lie to your attorney. You have a right to be your own attorney, all of which result in about the same thing. But the self-represented cockfight guys, one of my favorite bits was one of the guys who was defending himself, and he couldn't possibly be involved in arranging this cockfight because he was on a cruise, probably on the Grand Princess, not getting coronavirus, up until the day before the fight. And he submitted as Exhibit D for the defense his bill for the Princess cruises that showed that he was on the Princess cruise the 4 days immediately before the cockfight. And I thought, well, okay, sure, why not? Mark it as an exhibit. And I'm looking at it, and I can see on the exhibit, there's that big section where they overcharge the crap out of you for making ship-to-shore telephone calls and internet use and messaging. And he paid like $400 to Princess Cruises for his internet use. And I'm going, well, it's not my job to tell him this is not maybe a good piece of evidence to submit to show that he was incommunicado, but sure, go ahead. That's defendant's D. And then the DA, of course, picked up on it. And it was just, they don't understand what they don't understand. And sometimes I find it amusing, but I'm not allowed to laugh openly in court because that's wrong.
Have you had any crazy violence or disorder in the court stories?
Yeah, I had a guy who was accused of, he was sort of a scary guy. A couple had put out some firewood for sale, and they're like in their 70s, and so the gardener chopped down the tree. They left the wood. They want to sell it for firewood, so they put a Craigslist ad. And at 10 o'clock at night, the defendant shows up and says he wants to buy the firewood, and they think that's a little weird. And they kept saying, come back in the daytime. And that's when he pushed himself into the house and started beating the crap out of Grandpa, out of the old man. And Mom, bless her heart, came down the hallway with her sewing basket and took her letter opener out there, and with all her 85 pounds applied the letter opener to the defendant's neck, producing a red mark and a scratch, and she got beat up too. But then he left, and the cops called. They PC patrol checked the neighborhood. They couldn't find anything. They had dogs searching. The next day, he went to Big Five, and he bought a knife, a shovel, duct tape, and a tarp. And he went back to Grandma and Grandma's house. And I should mention he'd been in prison for a lot of his life, and he's a little crazy. And he cut the phone line, and he started knocking on their door, demanding that he come in. And I guess while he was in prison, he forgot that people now have cell phones. And so they called the cops, and they came up, and they arrested him, and we go to trial for attempted murder, which I thought the DA was going to have a hard time with, but turns out not. And during the trial, he didn't think things were going well. And I should have mentioned he's a big guy. He looks like baby Huey. And at some point, the deputy goes to take him out of the cell, and he decides to attack the deputy while he's still waist chained. I mean, he headbutts the deputy, knocks him down. There's a big fight in the courtroom. The jury isn't there yet. The deputy beats the crap out of him with those big bronze jail door keys and produces a lot of blood. And he wound up, he was subdued, and he went off to the hospital to be repaired.
I have to jump in on that. That's the first time I've ever heard of keys used in self-defense effectively. Yeah,
he bent one of the bronze keys. I mean, he hit that guy hard. Ladies and gentlemen, there's been a brief interruption of the trial. Don't worry about it. Just come back tomorrow morning, and we'll get going again. Sorry for the inconvenience. Have fun. Next morning, the defendant's back, and he's got a row of staples down the middle of his forehead.
He fell.
At some point, we start the trial, and at some point, he stands up and shows the jury how the deputy beat him, and he's yelling and screaming, and I had to excuse him from the trial thereafter and put him in the holding cell, inviting him back periodically if he could behave, and he didn't want to come back. But so occasionally, we get that kind of stuff, and I got to push my little button onto the bench and all the other good stuff. But fortunately...
Have I told you that story about the little button under the bench?
No. Tell me your button story.
I have a story. So I come from a family of judges and lawyers. In fact, I'm the only male in my family who is not a judge or a lawyer. I'm the knuckle dragon loser pilot. So this one time, I'm a little kid. dad takes me to his courtroom while he signs orders for the, over a Saturday. And I'm playing around on the bench. I'm banging the gavel and, saying you're guilty or whatever it is I saw in Law and Order when I was 5, because I was that kind of kid. And I saw this little box underneath the desk of the bench, right where the judge sits. And it's connected to the phone line. And I'm like, well, what's this thing? Is that part of the phone or whatever? And I push on it, and like one of the sides of the box pushes in. And I'm like, ooh, I probably shouldn't have touched that. And I go on with my day. Well,
never mind. Nothing will happen.
Yeah. So Monday happens, and I go to school, and I come back, and my dad comes home from work, and he's like, "Did you touch anything at the bench?" And I'm like, "Probably not.
Maybe.
I have a Fifth Amendment right. I choose to assert it right now." And so my dad was a federal judge, and so it alerted the entire federal law enforcement apparatus of my home state. And so at 7:31 a.m. when all the marshals rolled in to their jobs around California, all their pagers went off all at the same time, and they all rolled into that courtroom. And he's sitting there like signing orders, drinking coffee, whatever it is he does, and like, "You okay, Judge?" And he's like,
waiting for the duress word.
Yeah. He's like,
So curiously,
yeah.
Just to appeal to all parts of our audience here on the show, I'm a concealed carrier. And we've recently, I'm the chair of the security committee, so I was insisting we do active shooter training involving the judges. And a couple of things I learned from that is there's not a real good concealed carry configuration when you wear a robe.
You got to put
maybe
slits
an
in
ankle holster, but it's tricky. The other thing is I made sure that our benches are Kevlar.
Yes.
So our script is for the judges to duck down, get the heck out of Dodge, let the deputies, the bailiffs do their thing. Don't have them worrying about you. Get in your chambers, secure it, and wait for help. Wait for the secret knock.
Yep.
The other thing I learned, it is impossible to crawl rapidly while wearing a robe, and that cost me a new $200 robe.
Robes are not tactical.
Yeah.
Good info.
No.
It's good. It's tactical
So,
clothing.
So ankle holster it is while you're in court, or one of those things from someone who's not your sponsor that sit under the bench and open when you use the key. I always told my deputies to wear double thickness vests at the back in case I'm putting down suppressive fire in any direction.
That's
Nice.
good.
Yeah.
You brought something up a few minutes ago when you were talking about the guy that got beat up and the jury. You're like, "Hey, we have a little bit of a delay. Don't you worry about a thing." A lot of things get hidden or concealed from the jury, right?
Sure.
Can you talk a little bit about that? And the first thing that comes to mind is like in DUI cases, impairment is a word that the jury has to decide if a person is impaired. And so you're not allowed to say like, "Oh, it indicates impairment." Like that's a bad word if you're the officer on the stand. So you have to say like consumption, signs and symptoms of alcohol consumption, not impairment, and those sorts of things. And there's all kinds of stuff that gets kind of held from the jury. Can you speak to that?
Well, so juries have a role in the system, and they're to process the facts in the case and decide whether or not the DA can meet his or her burden of proving this particular defendant guilty beyond a reasonable doubt and to a moral certainty of the particular offenses that are listed on the complaint or the information. So we try not to complicate their decision-making process. So criminal histories generally aren't in front of the jury unless there's a particular reason for it. The opinions of everything. So the opinion of the officer saying, he was drunk. Even though it's a very good lay opinion and all of us know when someone is drunk, or at least have a good idea of it, ultimately somebody else's opinion isn't helpful to the jury, except in some cases of expertise. But because it's only their own opinion based on the facts that they've received during the trial. So there's a lot of stuff they don't get to see. Like search and seizure motions, right? That's a judge thing. So there'll be motions before the trial about whether you had probable cause to go into the glove box or stop the defendant or search 1234 Main Street with this warrant. But we don't ask the jury to worry about what is or what isn't illegal search and seizure. When they get to that point, they just hear that it was, I did a car stop, he had dope in his pocket. Here's the dope. It's a usable amount. It's his. Hugs and kisses, Officer Bob. So we narrow their role, and we try to make sure that we don't distract them, I guess, with things that aren't helpful to them in reaching the ultimate decision they need to reach.
In some of these cases that I've been a part of, the argument is essentially that, and it's usually the defense doesn't want someone on behalf of the prosecutor to say or use certain things in their testimony because it's going to prejudice the jury. And you mentioned criminal histories. I think that's a good example of one. But
pay no attention to the 6 prior DUIs this guy had, including 2 in the last 3 months.
Right.
Ignore that.
Right. And so I think a layperson might feel like, well, isn't to prejudice the jury that the person is guilty or not guilty kind of the point?
That's what we're doing here.
It leads us to another area, which is the exclusionary rule, or what the legal system calls fruit of the poisonous tree. And do you have any good examples of a time that something crucial got suppressed under that doctrine?
Yes and no. I will tell you that everyone worries about, especially officers who worry about their case getting lost on a technicality. I had that guy good to rights on a class 3 felony, and the perp walked because of the warrant was 2 days out of date or something, or the judge signed it but didn't initial it, or whatever it is that the cop is complaining about. I will tell you that technicalities are real, but they're extraordinarily rare. I have a hard time thinking of a half dozen cases in 28 years on the bench where evidence or other sorts of things made a critical difference. Now, maybe part of that is if the DA knows that up front, maybe the case just doesn't get issued if there's a problem with the PC for the stop or some other sorts of things that arguably could be considered a technicality. But it's fairly rare. And the second part of that is, even when it occurs, it normally doesn't mean the defendant walks free. It normally means that he'll plead to a lesser charge. So instead of a murder, it may be a manslaughter or an assault with a deadly weapon or some other sorts of things that hold him to accountability to a lesser degree rather than just walking out. I can honestly say I don't think I've seen anyone just walk out of court on a technicality. It's just not the way the system works. On a philosophical basis, now this is just Ned talking, I think the suppression rule is on shaky grounds. It's a judge-made rule. It's been around forever. And if the constable errs, the criminal goes free. The theory is that it will teach officers not to make mistakes or to take shortcuts in processing police work, and which is a good theory, and again, made up by judges who have put it into our law. But I don't think that is factually true. Again, just as Ned Lee speaking, and when I suppress evidence, and I do when I'm required to do so, I follow the law. But I think that in this particular case, the law is based on a faulty premise, because I don't think there's any empirical evidence that it actually changes police officers' behavior. I talked to academics. I've done literature research. We can show that it changes the training police officers get. And let me submit this counter hypothetical. And if you're Officer Ned working 4 a.m. on the graveyard shift for the University of California Police, and you make a car stop, and you operate as I did under the theory of just because I can't find your dope legally doesn't mean you get to keep it. If I had a case, then I would file that. And suppose there's a motion to suppress, and I get called to court, and I testify as I testify. I always tell the truth. And the judge says, sorry, Officer Ned, the evidence is suppressed. Case is dismissed if the DA doesn't have anything else. It's not like the judge calls my sergeant and says, hey, Ned behaved inappropriately and requires retraining or something like that. What happens is the case goes away. I get 4 hours of overtime minimum, and I learn to rephrase my testimony going forward. I think there's a real cost to the suppression rule. I think, you can remember, we never suppress evidence of innocence. We only suppress evidence of guilt. So by definition, that means the societal cost of letting guilty people be held to a lesser charge or less than fully accountable or even walk free. they will commit a certain number of crimes. There's a cost to society. And then you have to weigh that against the benefit to society. And I'm not sure I see it in the way that Judge Learned Hands and many of the wisest judges that we've ever had did in the early part of the 20th century when they created the suppression rules and the silver and the fruit of the poisonous tree and the silver platter doctrine and all of the other things that lawyers love to talk about forever and ever. It's a two-edged sword, so I don't think I want the suppression rule to go away, because I do want to discourage cops knowingly violating somebody's rights. That can't be a good thing.
Have you ever seen that?
The only other way to discourage... Go ahead.
Have you ever seen that? Have you ever seen what you would describe as plainly obvious abuse by cops in that regard?
Well, I've seen some carelessness, right? I once had a cop come in and testify fairly recently that it was a consensual encounter of a guy in a strange place at a strange time, 3 a.m. in a dark alley or whatever it is. He's not detained, but I pat searched him and found some dope in his pocket. And the DA said, well, what were the factors that you considered in doing your search, your pat search, your Chamel search or whatever that is? And
Terry.
The guy said,
Terry, right?
I just search everybody I stop in the alley late at night.
Shady in a no shady zone.
Yeah. And the DA was saying, sure, but I'm sure there were some articulable, officer safety sorts of things that you could tell us about. High crime zone, bulges in the pocket. No, I just search everybody.
Just grab everyone I see.
Thank you, officer.
Damn it, dude.
Come on, man.
And that's a training problem that started, I'm sure, with his FTO and maybe a culture problem within that particular police department. So I honestly don't think cops go out of their way to plan and conspire to deprive people of their rights and to make cases that they couldn't otherwise make. Are mistakes made? Sure. God knows I've made mine. Well, probably more than my fair share of mistakes. I've seen cops, be unnecessarily physical at a time that they don't need to be physical. I've had someone that I was booking into the jail and who said something unfortunate to the booking deputy who was on the other side of the stainless steel counter. And the booking deputy whereupon grabbed my arrestee's head and slammed it into the counter, producing a wound that would require later 3 or 4 stitches. And I remember this because we got in a big argument. He wouldn't accept the guy because he needed to go to the hospital. And I said, he may need to go to the hospital, but I didn't do that. This is your problem. And so I called my sergeant, and the jail sergeant had a long discussion. I went 10-8. But it did reinforce me. You should never say inappropriate things to the booking deputy.
Yeah, probably true, but obviously also not okay. There's a couple of little things that over the course of my career, I had a murder weapon that got suppressed. We did a protective sweep of a house, which in my eyes was a lawful and reasonable entry into the home, and inside we saw the shotgun in plain view. Ended up being the murder weapon, and I think that it was largely a kind of a technical error in the argument itself. Part of what I said had gotten lost, and it was a good lesson to think about, the things that are going to come up when you go and make that entry into the home. And then more recently, playing into what I was talking about earlier, which is the tactics of the attorneys, there was an example where we were talking about, it was a DUI suppression hearing, and they were discussing whether or not the driving behaviors were an indication of impairment. And the prosecutor never asked me specifically about the correlation between that defendant's driving behaviors and impairment as, determined by National Highway Traffic Safety Administration guidelines and stuff. And so I think the defense attorney let that be and waited until I got off the stand to bring that up in his argument, that there was no correlation and that the prosecutor basically didn't open that door. And so there's nuances in there that I just think are good for people to think about. And I think what you said, Ned, about carelessness is a big one, because what I see with a lot of rookie cops is good instincts. It's not that guy isn't shady. It's not that it isn't suspicious. It's just that they're going strictly off of their instincts and not able to explain or break down or illustrate what it was that they were seeing or why. And with training, like you said, and I think this is important to point out, because the goal isn't to say, hey, we're going to take these cops and we're going to train them how to articulate these better. In other words, bullshit their way through it, because that's not what we're doing. It's, no, that guy was objectively shady. I just noticed details that the rookie didn't.
And write them down.
Well, sure. And now you have learned that in a homicide investigation, particularly, you're going to get a warrant. You can do something, you may see something, but you're going to freeze the scene. I like officers that freeze the scene and then wake up some judge at 3 a.m. to get a search warrant for evidence that they will find. Warrants are free. Granted, when I was a cop, I had a theory that if I had to be awake at 3 a.m, the fucking judge could be awake at 3 a.m. And I'm not afraid to admit, with additional experience and wisdom, I'm not sure that's always true, at least on my week on duty. But, serious cases deserve serious work. And if it's a felony, it requires felony work. And search warrants are something that make it much harder for the defense to contest things. And maybe you saw something while looking in through the window. It made you want to freeze the scene and provide probable cause to a judge to issue the search warrant to recover a murder weapon and other indicia of occupancy and that kind of stuff, and do that. And by the same token, I've had people call me at 3 a.m. for a search warrant, and the officer will say, hey, I need a search warrant to get into this briefcase. It was a DUI stop. It's righteous. But I think if we look in this briefcase, we're going to find 8 ounces of dope. I said, why do you think that? They said, well, I found a scale and some other stuff. And what was clear after a few minutes of discussion was that he'd already been in that briefcase. Yeah. and he needed to do that. He didn't say that, and I wouldn't say that on tape. So my answer was, so what happened when you asked him for consent? Oh, hold on. Okay, Judge, never mind. Good night.
That's good. In the context of probable cause, and that's been a theme through a lot of this discussion, and that's what gets evidence out is, failure to satisfy probable cause or to get a warrant. What are the biggest myths and misconceptions you see among law enforcement, and then also just among the civilian population about the law?
Well, for cops, they think getting a warrant is more complicated than it is, or only a detective can do that, or you have to be a peace officer 3, step 4 before your sergeant will let you do it. I don't know, maybe that's true. But it's just filling out an affidavit. Hopefully you can have it checked by a DA for legal sufficiency, and then you submit it, and I look at it, and I swear you, and I either sign it or I don't. It takes about 10 minutes. These days, they're electronic, right? You put them in e-format, you send them to the search warrant at court.gov, and they arrive in a big stack in my chambers, on my email, and I look at them, and I electronically sign them and send them back to the officer. They're really a zero effort, but highly important thing. And of course, the civilian public is sort of the opposite way. I mean, I'm sure you've arrested people who say, you didn't advise me of my rights. And you're saying, you're right, you better shut up right now. Please shut up, because or I'll advise you of your rights. Oh, okay. So folks, lay people don't have a great idea. I mean, God knows how many years Miranda has been on television, starting with Jack Webb and moving forward. So they have a big notion they're entitled to have an attorney, which is a good thing because you're going to tell them that too. But beyond that, they don't have a sense. And of course, as you know, probably better than I, the police station and talking to a police officer is a truth-telling stimulus. A lot of people say amazingly incriminating things after Miranda in the appropriate place at the appropriate time because confession is good for the soul. And they don't have an attorney whispering in their ear saying that's maybe not the brightest thing to say, young man. Or on pretext phone calls, or the officer will say, here, write a letter of apology to the victim in this case. And the guy will write an honest, sincere letter of apology that shows up in his court case somewhat later. So I've lost the question now, but I think both the cops and the public sometimes have a fundamental misunderstanding of the role that the law plays in the start of a case.
What about the CSI effect? Have you had juries just completely miss the point or not see something the way you would see it And is there a remedy for that? And for anyone listening to this that doesn't, the CSI effect is like juries nowadays, they watch, and I don't know if this is in your eyes, Judge, really a thing, but people watch TV and they see CSI, right? The TV show CSI, and they think that like, oh, you could just go get his DNA and put it in some magic scanner and it's just going to tell him, what his favorite color is and all these things. And they have an unreasonable expectation in that sense when it comes to the state making its case. And so that's what I'm referring to.
Why didn't you fingerprint the baseball hat? Well, because you can't. It was in his pocket. He admitted having it. Well, why didn't you fingerprint the dope? Yeah, why did you test the DNA on the packet? It was in his pocket. And so, yes, but that's, I think, the DA's job, and I think they're pretty good at talking about that, and they will often talk exactly about that, the CSI effect, that there are limited resources, and of course the defense will say, the people have unlimited resources, but DAs don't have unlimited resources, and car stop, dope in the pocket is not going to have a lot of CSI involved in it, except for the gas chromatograph analysis of the dope. So I think it's an issue, but I think most people deal with it successfully. And I agree that jurors can arrive in court with an unrealistic expectation. That I think body cameras have helped. I'm a huge body camera fan because I think they always help the prosecution. And don't help the defense just because the defendants never look good at 3 a.m. when they're being arrested and when they say silly things. Now, having said that, officers sometimes get a little carried away with stop resisting, when clearly they're not resisting. And in fact, they're encountering corrective behavior from 3 or 4 officers simultaneously. But
in different directions.
In different directions. I was going to tell you, when tasers were new and only sergeants had them, one morning at 3 a.m, I was wrestling with some guy in a rainstorm in a park, trying to get him into custody. I can't even remember why.
Was he naked?
And the sergeant comes, no, but you're touching and doing everything. And the sergeant comes up and says, hold him still. And I hear this tick, 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 tick. And all I could do was thinking of my high school physics class, Mr. Fenn, and my physics teacher. And I was going, 50,000 volts, water, contact, damn it! And it was a long moment waiting for that. And of course, I didn't feel it, and we successfully took the guy into custody, but it was a bad moment for me as a police officer. Always have faith in your supervisors, kids.
Yeah.
You mentioned earlier a guy had many run-ins with the law, which is not a unique story. Do you have a take on recidivism and what works, what actually keeps people out of your courtroom?
Oh, wouldn't it be nice if we had a good handle on that?
Yeah.
I run into recidivism mostly in the context of sentencing, and that's one of the things that I, of course, either the law requires or discretion requires that I take into consideration. And, defendants always have been programming since they've been in jail and gotten their GED and taken sobriety classes and, all the good things, and probably with the right intentions now that they're sober and have been sitting in the bucket for 30 or 40 days. But sadly, statistically, the best prediction of future behavior is past behavior. I'd like it not to be so. I'd like the government to be able to know ways to change people's behavior, but that's kind of 1984 scary. If the government could effectively change people's behavior, could they be trusted to have it? And certainly some people do well. Substance abuse is tough. It leads to a lot of other crimes. We've tried punitive measures. We've tried medical measures. It's really hard to say that we have some sense, a third people get worse, a third get better, a third stay the same. And maybe I'm just cynical when it comes to this after so many years in the criminal justice system. But it's very hard to predict when someone who says, I had a problem in the past, but I'm okay now and things are looking good. And they believe it when they say it, whether it's true or not. I have no magic 8-ball on that.
You mentioned cynicism, and I think it's easy for people to be cynical about the legal system, right? The cops are concerned the guy's going to get off on a technicality, and anything they do is going to, get negatified. made more negative than it was by the media. I think most citizens, or many citizens, are concerned that they won't get a fair shake with the legal system, and they have anecdotal experience to support that. Can you talk to us about why we should believe in the legal system, and instances you saw at work or anything like that?
Oh, that's easy. It's the jury. Our jury system is a wonder. We talk about it and we don't really appreciate the beauty of it, that those 12 citizens standing between the power of the government to punish and you and me when we are miscreants. I spent a lot of time teaching for the State Department to judges in Eastern Europe where they don't, as a civil law place, they don't have criminal juries. And it is just so apparent to me the genius of the English civil or common law system that allows juries to stand between the government and the people. I am always astonished that the jury gets it right as often as they do. Between defense attorneys trying very hard to make sure their clients' rights are respected, and prosecutors trying very hard to make sure the adversarial system, people pushing so hard, and the juries see the truth. I can't even tell you the number of times that I have just been, even when they bring a verdict that's different than what I thought they would bring, I will look back at it and say, yeah, it's reasonable. Very rarely do the juries miss the boat. They are the savior, if you will, of our system. And I wouldn't have it any other way. I'm happy to call balls and strikes and let them do the heavy lifting and assess the credibility of witnesses and the strength of the evidence.
What things are, I mean, obviously we've talked a lot about the balls and the strikes and the things that you have to call versus what the jury gets to decide. And I know a lot of that is determined by law, and obviously some of that might vary from state to state a little bit, except for the stuff covered by case law. But can you give us a basic synopsis of what things you decide and what things the jury has to decide? Like how much, you talked a lot about discretion in there. Where are the left and rights on that?
So in theory, the judges do the law and the jury does the facts. Now, remember, of course, that 98 or 99% of all the cases are resolved by plea bargains. But in a regular litigated case, I decide what evidence goes to the jury and make sure the evidence is sound and trustworthy and believable and can be presented to them. They get to decide who they believe, how much of each testimony they believe, and the weight to be assigned to any of the evidence, and then decide if that proves beyond a reasonable doubt and to a moral certainty that a particular defendant is guilty of all of the elements of a particular crime. That's at the great risk of oversimplifying the system. That's what they do. But basically, I've got the case from charging. I do arraignments. I do the settlement discussions. I tell the DA, you've got a great case or a crappy case. I tell the defense attorney, ooh, you might try another one. That one's got no jury appeal. Try something else. I'll suggest alternative charges and do all the magic that I do as a senior experienced judges in trying to get the attorneys to come to an agreement that the defendant can live with and the DA can live with. But when push comes to shove, the juries are the people who hear the facts and decide. And my opinion is secondary. I might have thought the guy was guilty. They said no. I might have thought the guy was not guilty. And they said yes, or in a close case. All right, that's not a great example because I do have the ability to acquit him after a guilty verdict. But
have you ever done that?
No, I've never had to do that because, as I said, the juries by and large get it right. Every once in a while, I'll take an allegation off the table or do something like that. But officer discretion is much more complete and fun, if you will, than a judge's discretion. I am penned in by the law. Sentencing, I have a limited set of choices I can do. I can sometimes dismiss charges, but I have to justify it, and I should be able to justify it. But the difference between me dismissing a charge in my discretion and a cop simply not charging it at 3 a.m. and not turning in the paperwork is night and day. Police officers can do much more justice, much more efficiently at their end of the system at the intake end.
That was well put. I like that.
Throughout this conversation, and it's always interesting talking to you, Ned, because every time there's a wisdom behind everything that you say, but there's also a simplicity behind it that's like, oh, well, yeah, like
practical
obviously.
application.
And the officer discretion thing is something that I'd like to hear more about your philosophical. I'd like to hear some of your philosophical wisdom behind officer discretion, because in our system, police officers have the discretion to give warnings, and as you said, arrest or not arrest. And I'm curious how you feel about that, and how a police officer should approach those sort of interactions with the public.
Well, it's indispensable, of course. I mean, I can't imagine what life would be like if everyone was a RoboCop and said, I'm citing you for littering, and I'm doing this, and I'm doing that. Police officers are the direct interactors, the direct interveners in the community, and they are responsible for basically the safety of the community. And you can't live in an agency or a community where the cops cite everybody for everything they see, despite the rookies at 3 a.m. who are waiting for a taillight out. The reverse is true. You also can't live in a city like, say San Francisco, that says we don't give a crap about auto burglaries. We're just not going to respond to them. We won't take paper. We're not doing that. Or lately with their new DA, we don't do gang enhancements anymore. We don't do gang charges. We don't do 3 strikes. So there are left and right limits of how to make discretion work. But when you do it right, it's critical.
And how do you think we get it right? I mean, what would be your guidance to a young police officer in terms of getting that right?
After you've been around for a couple of years, it's in your heart, and you'll know. You'll know that it's not right to cite grandma for this particular thing. I mean, on the same token, if grandma is driving and she's a hazard to the public, you don't have to cite her. You could simply, I used to send a lot of grandmas to the DMV for re-examination, because that happens later and I don't have to tell them about it. But I wish there were a set of mechanical 1, 2, 3s. This is the gift of an experienced FTO. This is the gift of an experienced sergeant, and just a culture within a police department. And I don't have to tell you that there are police departments that are more successful at establishing a culture of discretion and some that are less. I don't think there's a magic formula that I can recite.
I got one. People, ideas, and then hardware in that order. Like, it's not like body cameras, and you mentioned body cameras earlier, Judge, and I agree they're invaluable, and I've had nothing but good. It's been nothing but helpful to me since I've gotten one, and I worked in an era that didn't have them, and but it's not the solution in and of itself. And I think exactly what you said: good culture, good leadership, good peer accountability is a big part of it. So I think those are all good inputs. Has there ever been? Actually, this is just a fun fact question. Have you ever had any of your rulings become case law or get overturned, or any interesting stories like that?
Well, much more overturned than becoming case law. As you know, appellate judges are terrorists. They operate in groups of 3 because they're afraid of single trial judges. And those terrorists from time to time will visit my cases. And of course, every criminal case I've done to trial gets appealed, because appeals are free, and they should. And I'm happy to have my errors corrected. For the record, I'm happy to have my errors corrected. I welcome the overlords. But I've had several cases reversed, and every once in a while it's a 2-to-1 reversal, and then I think, well, that's 2-to-2. It's a tie.
Good point.
But I did a self-represented litigant once, and he was exasperating. He was a 3-strike guy who was up for his burglary, and we all knew he's going to get convicted. He knew he was going to get convicted. He's good for it, so he spends his time filing motions, and he needs an investigator, and he needs to interview this, and he needs $1,000 for that, and all of those motions that take us in, just trying to get the horse into the chute to start the trial, because there are jurors that are coming on Monday morning, and we need to get going. And at Friday at about 5:30, we get through all of his motions. We're finally in a position, and we got nothing to do except start the trial. And he says, "Oh, I need civilian clothes. I don't have any civilian clothes. I don't want to appear in a jumpsuit in front of the jury." And it's now Friday afternoon, 5:30. And so I'm not quite sure what the right answer to that is, but I know specifically what the wrong answer is. The wrong answer is, good luck with that. And that was a 3-0 reversal, and I had another opportunity to try him. One of the right answers, by the way, is the public defender's office maintains a closet of clothing that defendants, even self-represented litigants, can use so they can appear in civilian clothes for their trial and avoid biasing the jury. So I got to try that case twice.
That's awesome.
Yeah, and there was another case where there was a guy who had just been released from prison and was on parole for vehicle theft, his third vehicle theft,
Of course.
and 2 months on parole. So there was a mom and pop market, just a grocery market, one step up from a bodega. And they had decided to do grocery deliveries for a while, so they had a little tiny pickup truck in the back that said Mom and Dad's Grocery on the side. But the delivery thing wasn't working for them, so they stopped doing that. And 3 months later, this truck is still parked behind the market, and the defendant came across it, and he asked for a flatbed tow truck, told them that he'd lost his keys. They had to use liquid soap to get this truck up on the flatbed. And it was covered with bird poop and God knows what, because it's been sitting there for 3 months. And he got arrested after it was reported stolen with it in his driveway when he was trying to replace the ignition lock. And he got tried for vehicle theft. And the jury asked a question during deliberations if it's possible that he didn't know it was stolen. The defensive mistake, if you will, that he thought it was abandoned property that he could take home with him. And I was improperly biased by the fact that he was on parole for vehicle theft, had 3 previous vehicle theft convictions, and I was pretty sure he didn't think that this was a lost vehicle that had no home.
Due to his extensive professional experience with vehicle theft.
So it would have been misappropriation of found property, a misdemeanor, instead of vehicle theft with 2 prior prison terms. And so I told the jury not to worry about that and to simply decide. And so they convicted him, and I sent him to prison for, 6 years, something like that. And that came back to me, and the judges said, hey, because I think I'm still right on the law. There was no evidence that it was misappropriation of found property. The only way there could have been evidence is if he'd gotten on the stand and said, hey, I thought it was lost. I thought it was, lost property, and I took it. Since there wasn't any evidence of that, I said, you're not getting that instruction. The Court of Appeals said, well, the fact that it was covered with bird shit is an objective indication that the property was lost and uncared for, even though it was parked within 10 feet of the owner's market. So I took that to heart, and I said, it was probably me. I should not have done that. And so it came back, it was reversed, and the DA let him plead to some misdemeanor or something or other, and he got credit for time served.
Good for him. Bless his heart. That's all you can say.
I had one from a listener that asked when I was putting this outline together for this episode, has there ever been a case or ruling that you were a little bit on the fence about and you made a ruling that was difficult to reconcile? Something after the fact that you're like, I'm not sure I should have been as harsh in my sentencing, or I'm not sure I should have let that guy walk, something like that.
Sure. Sentencings are I think, sometimes the toughest thing that we do. And I think the toughest sentencings that I had to do, now, child molest cases are easy. There's a lot of years involved. And I've sentenced guys to 250 years in prison before they can apply for parole. Good luck.
See you later.
Yeah. But there's cases, misdemeanor manslaughters. I don't know if your state has that kind of thing, but it's a simple negligence manslaughter. So you're driving down the street and change the radio, or a cigarette drops in your lap, or whatever it is, and you wander into the bike lane and take out grandma and 2 kids, or something like that. You didn't intend to kill them. You're not drunk. You just did what we've all done, which is not pay attention for a moment. And who among us hasn't wandered over a line when we do that? Those sentencings are brutal, because the victim's family will come in and death is too good for the defendant. We will never see grandma and those 2 kids again. And those 2 kids would have cured cancer. And they're good, solid people who are hurting in their lives. And they want me to know about it. And then the defendant's family will come and they'll say, well, you can sentence this guy. It was a simple mistake. Could happen to anybody, which is true. And, sentencing him to jail isn't going to bring grandma and the 2 kids back, which is true. And he won't be able to pay restitution if he's, making license plates, which is true. And at that point, it's tough. Those are the toughest ones that I just have to look in my heart and see what is the right thing to do. And in my view, in my world, retribution is not an evil term, right? There are just some things that society places a value on, and that's the value of human life, and particularly innocent life. And, you might have done something that we've all done, but this particular incident resulted in the loss of grandma and 2 kids. And that means I'm going to hold you accountable in some way. Mostly it's maybe a short jail term and a buttload of volunteer hours or something like that. But those cases drag with me for a long period of time. I had a guy who, he just drove off the road with his 4 friends in the car into a ditch. We still don't know why. All 4 friends were killed, including a pregnant woman. All 4 of them were drunk. He was probably drunk, but he wandered away and nobody tested him till the next morning. And with 4 dead people, of course, that means there's a satellite van out front and a lot of people and a 2-day sentencing hearing. And that was so tough. And I originally thought this was maybe worth 4 years in prison with the rest running concurrently. And then the family stood up and said, you look us in the eye and tell us which one of us is the concurrent decedent. Which one of us doesn't deserve any time in prison for this guy who killed 4 of his friends and walked away literally with a slight concussion? It was a horrible one. But my job is to make the decision. I make the call, and I call the next case. I don't normally go back and worry about it too much just because you can't. My job is to make decisions, and I do that in good faith. Once I've made the decision, I move on.
I'm going to pivot a little bit. You mentioned earlier about concealed carry, and I've personally seen a stunning amount of ignorance about self-defense laws nationwide, and they vary, state to state, and concealed carry laws nationwide. And I've heard things like, if you shoot a guy in your driveway, you should drag him into your house so you can say it was self-defense. Or you don't want to put night sights on your gun because some prosecutor is going to say you were looking for a fight. And I don't know how to reconcile that type of myth and misconception. And when I've asked my lawyer friends, a lot of times they'll say, well, I have to be very careful about dispensing legal advice. And then that puts us in a place where you've got kind of the blind leading the blind when it comes to legal advice and legal understanding. Do you have any advice for how we can raise the common denominator baseline understanding of self-defense law and concealed carry law?
So, of course, I recommend that anyone who conceals and carries to take some courses. In California, to get a permit, you actually have to go through a course that talks about those kinds of choices and talks about California self-defense law. But it's, I've had someone break into my house at 3 a.m, and I have been confronted with that exact thing, right? I immediately flashed on every young police officer's theory. I've been waiting for someone to break into my house for 20 years. How many times can I reload before it looks bad? But you're not capable of rational thought. You don't spend time going, well, there's this and there's that. Let me take a look at People versus Leon at 136 Calap 4 618. If you react with common sense and even under stress, I can't imagine that any of us will ever get into trouble. It's when we do silly things and chase people down. And there are even exceptions for that. It's a complicated area of law, I get that, but it's mostly common sense. If you just do what you need to do to secure your life and property or the life and property of others, you're generally going to be fine. You just can't consult a lawyer at 3:30 or 4 a.m. when something quickly happens. I wish I had better advice than that. But if you're going to carry, you need to at least do the prep work and go to the classes and do the things and maybe get a little insurance and do the other sorts of stuff that we all should do.
And in full disclosure, I'm partially sponsored by an insurance company for concealed carry, U.S. Concealed Carry Association. They don't sponsor the show, but I have a business relationship with them.
I can tell you from earlier, Ned talked about the officer discretion stuff, and granted, in a major case like a shooting, that's going to fall not necessarily at the officer level, but the supervisor or the detective investigator level, and maybe even the district or county attorney level. But I can tell you a number of times that I've gone to those sorts of calls, and in the ones that are legit, you're like, okay, yeah, I mean, good for him. I would have done the same thing. And those cases are never going to see, they're never going to see a criminal court. Now, civil court, different ballgame, obviously, but the ones that tend to get sketchy are exactly what the judge is saying, where the common sense part, oh, well, he wronged me, and so I'm going to go, chase his ass down.
Teach him a lesson.
And yeah, and like, okay, did that sound like a good idea, really? Like, you could have just called the police. That's where it starts to fall off the wheels a little bit. So
sure, he owed me $50, so I went over to his house to talk about that, and an argument ensued, and bad stuff happened.
Right. And Mike mentioned civil liability. You're in California, where that's like a hobby. Can you speak to us? I feel like often there's an irrational fear of liability, of getting sued. Can you speak to that? Of like, at what point am I applying good risk mitigation, and at what point am I just being phobic of lawsuits?
Well, let me start off by saying, as I must, that lawsuits are good.
Yes.
Having a court help determine a dispute is a good thing. Lawyers have children; they need braces too. And litigation finds the truth, and if the truth is in your favor, the whole point of the litigation is to find that and make sure that you're not liable when you shouldn't be liable. Having said that, it's always messy and it always costs money and all those sorts of things. But it's not wrong to have a court take a look at a situation where somebody got hurt or somebody almost got killed or something like that. Potential lethality is a perfect time for us to take a look at the participants' actions and motivations. So again, there's no magic formula to this. If you dread that sort of thing, then you should exercise your risk assessment and not put yourself in a situation where the risk of litigation is high. And that may mean that you don't carry outside your home or your place of business. I'm like most people. I have carried concealed probably for 40 years now, maybe a little bit more. Oh my God, I'm old. And I think I took off-duty action when I was still a cop, maybe once, involving a firearm. And even when I'm sitting right now, I can sit on the light rail and someone will say, "Hey, Judge." Of course, I will make sure that I unsnap the holster. But I have never had an opportunity to come anywhere close to a shooting except for the person who broke into my house at 3 a.m.
And one of the reasons I bring that up now is not just in the context of concealed carry, but one of my favorite sayings about it is the ability to sue each other reduces our felt need to duel in the streets, right? If I can sue you, I probably don't have to go to blows with you. So the whole point is civil litigation is what keeps society kind of civil and
peaceful-ish.
Sure.
Yeah. More
Look
or
how
less.
the English common law has descended to us, right? You could have a trial by jury, or you could have a trial by combat, or you have a trial by champion. We're the same sort of thing, and we've just stuck with the jury issue, so we don't have to kick people's butts.
So there's a transition there that I think is kind of beautiful. The Riot Act, and as it happens, Judge Lee was involved in the LA riots back in the day, right? With the National Guard.
On the good side. Yeah, on the good side.
Did you get a free TV that week?
Well, the problem was we were taking all those VCRs, but we could never get the remotes. They're no good.
No. First off, big picture, can you tell us a little bit about your National Guard experience and what you learned from it and how it shaped you and how you shaped it? And then if we can talk through some of your experiences maybe with disasters and deployments, that sort of thing.
Sure. When I was commissioned, I actually went to ROTC while I was in law school. And which was a little late in life. So I had my BA already. I had been a cop already. And so when they said, so what branch do you want to be? I said military police out of ignorance. I thought they had something to do with law enforcement. And I, of course, was wrong. It mostly had to do with killing Soviet Spetsnaz in rear areas behind the main battle area. And so I went to MP school in Alabama. I was assigned as a MP platoon leader in a National Guard MP company, later commanded a National Guard MP company. The beauty of the Guard is communities helping communities. And so I was ordered active duty in California, of course, for earthquakes and fires and floods and the occasional civil disturbance, which I think creates a much better experience base than my active duty counterparts who certainly deploy and do training and all those other sorts of things, but they don't get to do as many fires and floods and earthquakes and civil disturbances as we do. And so I got to be a task force commander for various floods in Marysville and, again, a lot of wildfire activity. And of course, as you pointed out, the occasional civil disturbance. And I was the commander of the 670th MP company. And I had been a judge for all of a year, I think, when the Rodney King riots broke out in Los Angeles. And I was still a little disappointed because my MP company was the only MP company in my MP brigade that had not been mobilized and sent to Desert Storm. I still don't know why that happened because I had the best readiness. I had the most people and all that other stuff. And I was holding their coats while they went downstream. The bright side of that meant because the Guard is both a state and federal organization, I had a lot of state military police equipment, which is to say some batons and riot gear that federal military police units don't normally stock. And so when the Rodney King riots broke out, you know how military leaders are, they look through the big plan of who's got the stuff, and they called my unit at, 2 in the morning. They called me at 2 in the morning. The brigade logistics officer said, hey, you're activated. C-130s are coming to pick you up in about 8 hours. Why don't you have you and your 157 guys ready to go? And so it was a huge learning experience for me, and it affected how I look through life. I mean, we always talk about junior leader initiative, and that was the best 72 hours I was ever going to have in the Army. In terms of junior leader initiative, as my leadership was unavailable to us.
It sounds like it was a riot.
But the junior leadership thing is cool. I think one of the things that I really liked about becoming a police officer coming from a background in EMS was how much more autonomy I had. And, you know, we talked about the officer discretion thing. It's having that being able to use your own initiative to make your own decisions and those sorts of things, I think is pretty cool.
Yeah, I was a captain making general officer level decisions for
awesome.
Period of time. I was the military field commander of Los Angeles. I was the only military unit the LAPD had contact with. It was hilarious.
Do you have any lessons from your disaster deployments that have changed, like how you personally prepare for disasters?
Certainly. I mean, one, I have a lot of insurance because a lot of people don't plan for floods and fires and civil disturbances as they should, and a lot of insurance doesn't cover that. And of course, I don't want to call myself a prepper. I like to prefer the term self-reliant and detail-oriented.
You do adulting.
And so, yes, I try to be an adult about these things. And so, you know, I have a couple of cases of MRE stashed away, and these days a lot of water and some other sorts of things, and a fire pump out by my pool, and all the things that I might need to take care of myself. Because when you do that, you see, and you're helping people, and you see a lot of them don't have defenses in depth. They are overwhelmed by the circumstances. And once they don't have power and the refrigerator has been off for 2 days, they have 2 cans of beans and a beer. And that's all that they've got to survive for the next 2 or 3 days.
At least they got that going for them.
Yeah, at least, but probably no can opener.
Ah, shit.
Yeah. I know you guys have done episodes on disaster prep, and we all need to echo that to be part of being a responsible citizen, particularly in a place like, well, I live in California, where there is no shortage of an opportunity to be self-reliant. And I hope when people listen to this in the future, coronavirus will be a quaint term that they'll have to Google to look up. But right now, that is an active concern that all of us are preparing for and trying to make sure that we're ready.
Yeah, I legit couldn't get toilet paper at Costco the other day, and I actually need toilet paper, not because I wanted to stock up.
Just use old police reports and warrants. You'll be fine.
One of
Bidet.
One of the disaster prep things that I got from, I think it was The Unthinkable, which is a kind of a favorite book of the show by Amanda Ripley. The sense of community, and it could be a different book. I can't remember.
It's in there.
The sense of community in terms of disaster prep, I think is, and the judge talks about being self-reliant, and that's obviously a good thing. But in this day and age, our personal networks are so spread out and electronic that we're not very close with our neighbors. And so since we're on the topic, one thing I would throw out for the disaster prep angle, now that it's come up, is just think about that in terms of like being friends with your neighbors and having resources and those sorts of things. And I know Jim has talked about that before, but it's something that's easy to lose sight of in this day and age that is going to become very important in one of those disasters. So,
oh, absolutely. I mean, I live in a semi-rural area. I mean, there are 5 houses on my street. We're surrounded by agricultural land, but within 3 miles of here is the city of San Jose with 1 million people. It's sort of an agricultural preserve. So we have board meetings. I know my neighbors. We all have keys to each other's houses. And that kind of interrelationship is critical in the event of, well, something as simple as a power failure or more substantial as we go through life.
And Ned also makes his own wine, so you know he's keeping his neighbors happy if he needs to.
Yes, and I have chickens, and we have a lot of eggs to trade.
There we go.
Yeah. So when the economy crumps, you'll have something to trade. I like it.
That's it. I may not have Krugerrands in my vault. I know you do, Jim.
I might.
Well, this has been really cool. And my last question, just kind of backing up a little bit to the 30,000 foot view, given all of your experience and everything that you've seen and all of your years as a Superior Court judge, is there anything looking back that you think we should try to fix or change about our criminal justice system? Is there something that you'd like to see us correct course on?
Well, if I were king, there's at least one little area I'd like to change with self-represented litigants. I've had because of the way the California sentencing laws work, which are kind of Byzantine and can be harsh for sex offenses, coupled with the fact that they made me the self-represented litigant guy, I've had cases where self-represented litigants who are accused of sex offenses have had the opportunity to cross-examine their victims. And there is nothing more heartrending to me or desperately in need of change than to have a molester being able to ask intimate questions about the victimization of a minor, or even an adult talking about a victimization when they were minors. It is heartrending, it is disgusting, it is disturbing, it is anything. And I just wish there were a way that we didn't have to do that. I know that's sort of a small niche answer to your large 30,000 foot question, but boy, I'd do that in a heartbeat if I could.
It might be a niche question, but it's certainly an impactful one, because that's a no-go for me. Not that I have a say, but I would struggle with that as well.
And my question for you is, if you could sit down every young cop in the country, you can give them 1 or 2 pieces of advice, what would you tell them?
Have friends outside the law enforcement field. Continue to relate in the things that you're doing. Understand that the people that you meet are a small subsection of society. Not everyone is a jerk. Not everyone is got a scam going. The majority of the people are good, solid folks. So, and just like your friends were when you were in school before you started working midnights and your friends wouldn't call you because they can't keep track of your days off. And you began to lose contact with anyone other than your beat partners and the other folks. Enjoy the world, do other stuff, do reading lists, and have hobbies and even careers outside of law enforcement. I was afraid to grow old and retire in the law enforcement community. None of your listeners will remember an old TV show called Barney Miller, Hal Linden, and some other folks who were detective unit in New York. There was a character called Fish, played by Abe Vigoda, who was a 60-something detective who was clearly 20 years past his prime. And that character scared me, that I would someday wind up as a 60-year-old line officer or even a low-level detective. And I just couldn't imagine myself doing that. I mean, it's fun when you're 20, and who doesn't like to drive 110 miles an hour with the lights on and hit people with sticks and all the other good stuff that happens? Or come home and tell your wife at 3 a.m, wake up, wake up, wake up. I had 3 DUIs tonight. Hey! Hey, as long as you're awake.
Said no one ever. Yeah, nice.
Yeah. So I just encourage them to look outside their immediate profession. I understand there's a bonding time and there's a time when you have to get into the culture of your agency. All of that's true, but you have to balance that with the rest of your life and family.
All true things, and certainly things that I've tried to wrap my head around over the last 12 years that I've been doing this. All right, well, I think that's pretty much all I have. Jim, do you got anything else?
Nah, I think we're good.
And Ned, is there anything else you'd like to share or send off our listeners with?
Not that I can think of. If they haven't gotten something out of the last hour or so, I don't know what I could tell them. I'm going to sit here and drink out of my bottle of water. Gosh, if only I had something else besides water to rehydrate me.
All right, guys. Well, please go and thank Ride-On Optics for sponsoring the show. Ride-On is bringing you high-quality HD glass from Japan. Their products are backed up with a lifetime guarantee. You can go check them out at rideonoptics.com. And also by Dryfire Mag. Dryfire Mag is a brand new sponsor, and they make a magazine that you can put in your gun, and it's used to reset your trigger for dry fire so you can pull the trigger more than once. You can adjust it with their spring kits and get different weight of trigger pull, and it's nice if you want to practice your follow-through and more than one shot in dry fire. Go check them out at dryfiremag.com. If you have any questions or feedback for us, you can go over to tacticaltangents.com. There's a microphone. You can click on that, leave us a message, and we can feature it on the show. You can find us on Facebook, Instagram, and Twitter. We are at TacTangents, and be sure to check out our website if you want to find any shirts or stickers. We put out new episodes on the 1st and the 15th of every month, so make sure you subscribe if you want to stay in the loop. And that's all we got.
Hey, if I wanted to contribute some small amount of money because of the quality of the programming, how could I do that?
That's
what a great
true.
question,
Thank you,
Judge.
Yeah, what a great question. You could also go over to Patreon if you want to subscribe to our Patreon and give us $1 for new episodes. That money's going to go back into bringing you quality content. And we've also...
What a bargain, because this was a $6 episode, and be able to get it for $1.
That is exactly right.
That's awesome. So yeah, you could go check out Patreon if you want to give us $1 for new episodes. And there's also a link for GoFundMe if you'd rather make a one-time contribution. And again, that's going to go back into the show. So, all right, guys, that's all we got. Good talk.
It was a good talk. Thank you so much.
It was.
Thank you, Ned.